Hello and welcome to The Big Fight. I suspect one of the big subjects of discussion during the entire year this year is now going to be the entire question of juvenile justice, and not just because of a couple of really high-profile crimes that do involve juveniles, at least one or two of whom are likely to go free, but the overall question: what should happen to juvenile justice? Should that age be reduced back from 18 to 16? How can you prevent juveniles from getting away with really serious crimes while at the same time continuing to protect the rights of children? It is going to be a tricky debate, and we are kicking that off right now in this episode of The Big Fight with a great panel. Dr. Aman Hingorani is the counsel for Nirbhaya's family, has been fighting in the Supreme Court on behalf of Nirbhaya's father to strike down the Juvenile Act as unconstitutional, and that one of the juveniles who might well be getting away thanks to this particular act. So, what does that mean? Shireen Vakil Miller is Director for Policy and Advocacy, Save the Children. She's against lowering of the age or treating juveniles as adults. Maxwell Pereira, former Joint Commissioner, Delhi Police. Great to have you joining us. Anant Asthana is a child rights lawyer. Thanks for being with us. We do have Dr. Subramaniam Swamy with us as well, who has filed a petition in the Supreme Court, and he's going to be talking on this. He has strong views on the subject. And we're also being joined from Bangalore by Kalpana Purushottam, senior professional counselor who's done a lot of work with juveniles. Why, Dr. Hingorani, do you think it's important to lower the age?
My personal views is that age is quite irrelevant. The yardstick, according to me, is the maturity or understanding of that particular person, whether he knows the nature consequences of his act. Now, the entire premise of the juvenile justice system is that a child does not have the capacity to make a decision or to know what he's doing. So by that logic, regardless of whether the child is 14, 15, 16, 18, if he does not have the maturity or understanding to know the nature or consequence of his act, he should not be tried in ordinary criminal court, but conversely, should that person, regardless of the age, whether 16, 17 or 18, if he knows the nature and consequences of his act, he has the maturity, then he should be tried in the ordinary criminal court.
Kalpana Purushottam, let me get you in. Do you agree with what he said?
As a professional counselor who's worked directly with children in conflict with law, as well as children in need of care and protection for several years, it is my firm conviction that children who are alleged or found to commit offences should not be treated as adults or under the adult criminal justice system. And secondly, it's also my firm conviction, born out of experience as well as validated research across the world, that children are exceedingly amenable to reform. Psychosocial maturity, as it is called, is something that adolescents do not develop. That starts in adolescence, but that process
but somebody who has the
is not
ability
to be
or the awareness enough to be able to brutally rape, torture and kill somebody at the age of 17, you don't think that person is old enough then to bear the consequences for that act?
Vikram, see, the act in itself, whether it is rape or murder, does not indicate or imply maturity. It does not. In fact, research in neuroscience and behavioral psychology shows that adolescents do not develop the psychosocial maturity that I am referring to till they are well into their early or even mid-20s.
Fair enough. So therefore we should defer it then till the mid-20s, I guess, would be the other argument. Don't punish anybody till they are really considered mature enough. Anyway, I'll just come back to you, Kalpana. Let me just get Dr. Swamy in on this note.
First of all, I have no objection to 18 being treated as the cutoff for the juvenile. But the United Nations conventions recognize that there are some crimes which they call as heinous crimes, for which the emotional, mental and physical maturity was to be taken into account. The law as it was drafted in 2000 was a faulty drafting, and it left out these particular qualifying remarks which are there in the United Nations resolution. So my petition is not so much to lower the age, but to say that in cases of heinous crimes like rape and murder, the emotional and physical and mental state of the person has to be taken into account. And there I have to tell you that, see, if a child robs a pastry in a bakery or a cycle, it doesn't affect the rights in a fundamental way of anybody else. But if he rapes somebody or if he takes away the life, then the victim also has a right which has been snatched. So therefore it has to be treated differently. I've said that let it be 18, but the proviso which has been missed out, which is there in the United Nations Convention for the Rights of the Child, should be read into the law as by the Supreme Court, which is empowered to do so. And in that case, the Nirbhaya trial would have to be redone again, because it has been tried under the wrong law, and it has to be tried under the complete law.
Okay, Shireen, let me turn to you. So, as Director of Policy and Advocacy for Save the Children, the point that he made about there being victims, and in this case, quite often the victims whom a 16 or a 17-year-old would prey on would be smaller children. So while you may worry about the 17-year-old or the 16-year-old and say, well, what about their rights? You have to say, what about the rights of a much smaller child who's quite often, in the heinous cases that Dr. Swami is talking about, has been murdered or raped or abused, or, all sorts of terrible things have happened.
Yes, of course. And I wanted to say just one thing on your a general comment before I come to that it's not like anyone is saying that these children or youth should be let off or are being let go. No, they're not.
Effectively, there are.
They're not being.
The juvenile who raped and murdered Nirbhaya is going to be out within a few months.
Not a few months. He's in for 3 years, which is the current provision. And if they see that that he has not been reformed or is not ready to go back into society, poses a threat to society, that surely can be extended. So it's not that they are being let off or let go. There is a system for trying and for keeping young people or children. It's not like there is no system. And the thing is that
there's a system, for example, in that specific case, and I'm going to come back to you. He is apparently right now, on the 16th of December, on the anniversary, he said, why are you going on reminding me? I want to forget about the incident. And having said that, he went off for his guitar lesson. You really have to wonder at some time as to whether, I understand there's a question of reforming. We've also seen other issues that as to whether reforms are possible at all in the sort of juvenile homes that we have.
There is a system, but that system is not strong enough. And we haven't quite put into that system. So those homes, the status of the homes are not good enough. The kind of counseling care, the kind of care that is needed for children and youth committing different levels of crime is not there, and we need to concentrate on that. And I just remember that there are the Juvenile Justice Act is for 2 groups of children. One who are without care and protection, who have been neglected and abused themselves, and the others who are in conflict with the law. And generally, the children who come into conflict with the law are because they have themselves been abused and neglected.
Maxwell Pereira, let me ask you, because you, having been a policeman, you've dealt with this. Have you in your career come across enough people at the age of 16 or 17 whom you would say are, you can argue as to what age you really become mature enough, but who in a sense are hardened enough to be carrying out crimes and knowing that they're doing something which is wrong and who therefore should be punished for it?
Most of them who come into conflict with law, this is my personal opinion, not necessarily of the police department or the government, but most of these category of youngsters, juveniles under the age of 18 or maybe 15 to 18 do know what they are doing. I personally feel they are very aware, and let me use the word street smart. They grow up in the crime field or in the life of crime, and they get hardened, very hardened, and then they commit these sometimes even gruesome and heinous category crimes. We should have a system of identifying this category of people for extra punishment and not treating them as juveniles.
As a child's rights lawyer, the same point which I had thrown some time back about the rights of a much smaller child who is typically the target of one of the more hardened people whom Maxwell is talking about at the age of 17. What about their rights?
I mean, when you say that I'm a child rights lawyer, I also represent children who are victim of sexual offences. So when we say that let the JJ Act survive, we are not blinded towards the other category of children whom we put in the category of victim. JJ Act is also about victims of not just crime, but also of all kind of abandonment, all kind of hardships which they are put to. So that's why we are saying that let the
Nobody's
JJ Act
saying
survive.
wrap up the JJ Act for
in effect it will
total.
mean
And
that.
for example, what Dr. Swami says, and Dr. Swami, I'll get you in on this in a minute, is that modify the applications of the JJ Act, and that's what, for example, even the move that was recently taken at the Ministry for Women and Child Development was that in the 16 to 18 bracket where somebody is committing a heinous crime, rape, murder, the likes, then perhaps they don't deserve the protection.
I mean,
Because somebody else is a victim who perhaps deserves more protection than these people do.
see, law is not made keeping in view only singular consideration. If we say that reduce the age from 18 to 16, then think about the number of children of the age group of 16 to 18 who indulge into exploratory sex, romantic love affairs. They will also go to the jail. Do we want our young children to go
Dr.
to
Sami,
jail for
would
that?
those people
How
also
do
go to
we deal
jail
with
if you
that?
change, but actually I think he was talking about it in the case of heinous crimes. It's not lowering the age of
What is heinous? What is heinous?
Yeah.
rape and murder is
What is-
heinous.
I mean-
torture at that.
I mean, we have to think about
Acid
what
attacks.
is heinous. Heinous.
All of these things are done by people who are
Heinous
17-year-old and
means-
16-year-old.
also looking at children as somebody who is solely responsible. Children are product of what we create. We cannot absolve ourselves saying that we will not do anything for children and we will just punish them if they go wrong.
If you have a 16-year-old who is committing a crime, right, like he's raping somebody, the probability is that he'd be raping a 3-year-old child. Now, whose rights at that point should you be
See,
concerned about?
rights of victims are not addressed by this particular legislation, but there are laws which protect rights of victims in criminal procedure code, in lots of other schemes, and that applies to the adult victims also.
So, Dr. Sami, let me just get you back in on that point.
United States has a provision that is the court can waive taking, a juvenile court can waive taking a case where it feels that it should be tried under the adult justice system. So in our case, what I am urging the court to say is that it will be 18 provided in heinous crimes for which we have a list, and that list is not mine, the United Nations list. The United Nations has given a list of rape, brutal murder, things where they are saying that you cannot commit these crimes unless you knew what you are doing. So the criteria became knowing what you're doing. So I think that is what I'm trying to read into the law, and not that every crime committed by a youngster should be treated as an adult crime.
Okay, Kalpana, let me just get you back in, because if you look at some of the statistics, they are in a sense reasonably alarming. Because if you look at, let's just take rape for example, something which we've spent a large part of 2013 correctly and justifiably concerned about. If you take a look at the statistics for the number of rapes that have apparently been committed by juveniles, from about 400 reported in 2001, it went to something like 858 in 2010. The statistics are showing that increasingly a large number of juveniles are being charged with crimes like this. So, and add to that a number of other cases where it would have been for smaller children in homes and in neighborhoods, that number might well be higher. So there is a problem here which we have to try and find a solution to. Let's not pretend it doesn't exist.
I think that we should look at it in the perspective of where does this fit in the overall scene of crime. Is it only juvenile crime that has increased, or is there a general increase in the rate of crimes and rapes against women and children in the country, which is one. The second part is about these juveniles who are committing offences of a serious nature like violence against women or children, that they should be sent into the adult system. Who is to make this determination? And if we are leaving the determination of this maturity of a complex question like psychosocial maturity to a juvenile justice board, I mean a question that even neuroscientists or psychiatrists or behavioral psychologists struggle with, there is
But
no,
Kalpana, at the
this
end
is
of the
not
day,
a blood
every
test or
crime-
a sugar test to say,
But Kalpana, every crime at the end of the day is put to the test by a judge who says, yes, this person deserves to be punished or doesn't deserve to be punished. This person is the rarest of the rare, so deserves a death penalty, or this deserves life imprisonment. every time there is a subjective judgment, and if you have to exercise the subjective test at some point, because according to what you yourself were saying earlier in the program, you could argue that people don't mature till they're 25 or 26. So does that mean that people should not be charged with crimes till they're 26? You know, where do you draw the line? You could say that
No,
at
I'm not
50
saying
you're
that,
not
Victor.
fully
What
mature.
I'm saying, no, I'm not saying that. See, what I'm saying is that maturity cannot be assessed. Maturity is not something that, you know, you can accurately say that exactly at 16 years and 3 months this person is mature, and that he knew exactly this person knew exactly what he was doing, while that person did not know what he was saying.
So, as
There
so you're saying what I'm saying, that it has to be looked
that
at
is what
case
I'm
by
saying.
case.
Accurate.
You have to look at it case by case then, right?
I am not saying it has to be looked case by case. No, I am not saying it has to be looked case by case. I am saying that from a developmental perspective, adolescence as a developmental phase of life, it is a normative period when adolescents will, they do not have the brakes yet developed. They are prone to risky behavior. Adolescents are prone to influences by, peers, by adults.
Okay.
They are lower levels of impulse control.
Dr. Hingorami, let me
All
come
of
back.
these make it very different.
Okay,
I
I
didn't
agree.
hear.
Yeah, Dr. Sami, you want to say something very quickly, then I want to come back to Dr. Hingorani.
Today, all that the juvenile court looks at is whether the school certificate is saying 18 or not. And the school certificate may be bogus. For example, in the case of this Nirbhaya, the mother said, I don't know the year he was born in, and we told the school principal, whatever you put, whatever you like. And there is no scope in the Act for a examination of even the school certificate, whether it was a genuine recording of a genuine age or not. Now, the second thing is, you can adopt the American system where a juvenile court can have a waiver, and it can then refer this to either a superior, higher level court like High Court and Supreme Court, and the Supreme Court can call the experts and ask the opinion whether this person knew what he was doing, whether he was mature enough. Okay. I'm not saying that for all juveniles you should scrap it. Certainly we won't do it.
Okay, so
you can think of reforming that.
So
but
again,
when a person rapes a girl or kills somebody, you cannot assume that this is a temporary aberration.